Magandang umaga, mga tagapakinig sa Free School of the Philippines at lahat ng inaanyayahan natin na makinig sa ating free bar lecture dito at yung mga nasa free online. Ako po ay private lawyer. Ay sa atin hong mga tinatalakay dito na sa tingin natin ay mahalaga sa mga pangyayari sa lipunan, ay tayo po, we are entitled to academic freedom. Oh, okay na? Oh, good morning. I am a private lawyer, and as a professor teaching pre-bar review, we are just exercising our academic freedom and freedom of religion, free speech, and free expression. A lawyer should be able to look at the issues from both sides. And as we have already discussed the possibility of a transitory revolutionary government, that is one side. Now, we will discuss the other side. Former Senator Enrile said that only the president may declare a revolutionary government. I do not agree. If we go to a review of the history, a revolutionary government is a regime of government outside the Constitution. And this is exemplified by the revolutionary government declared by former President Cory. You cannot say that it is unconstitutional because precisely the Constitution is set aside by a declaration of a revolutionary government. But the government in a democracy where all authority emanates from the people, any government, a revolutionary government at that, may endure only if supported by the overwhelming majority of the people. And we have seen that in the EDSA revolution. In a republican government, a democracy like us, it is the sovereign people that will decide any political question, whether a revolutionary government is feasible at this time, or there are other alternatives that might be considered, whether we should revise the Constitution, and in the revision, what is the pulse of the people, whether to go federal or to maintain the present unitary form of government with decentralized powers devolved to the local government units as provided in the local government code and as explained in the Mandanas versus Executive Secretary and Ted Garcia versus Executive Secretary laid down by the Supreme Court recently in 2018, and the executive order of President Rodrigo Duterte, EEO number 138, putting into place or implementing the decentralization and local fiscal autonomy in favor of the local government units with the corresponding provision that 40% of all national tax collections of the national government shall accrue to the local government units to be able to fund the functions of government that are transferred to the local governments. If only this decentralization has been implemented as provided in the local government code, and the decision in the twin decision in Mandanas and Garcia, then we would not have any problem with the Department of Health, because the construction of hospitals and providing for allied medical services have been devolved or transferred by the local government code, an act of Congress, pursuant to the provision of the Constitution on decentralization and local autonomy of LGUs. The problem is it has not been implemented, and we were overtaken by the pandemic. But to the credit of President Duterte, he is in the process of implementing it. And in fact, local government units have been required to plan for the transition that will take effect in 2022, because decisions of the Supreme Court interpreting or applying the Constitution and the law of the land form part of the legal system and shall have no retroactive effect. And the finality of the decision, as implemented by Executive Order 139, would have the effectivity in 2022. And that's why local officials like governors would insist on keeping their post, because they will be holding 40% of the national taxes collected by the national government. For them to plan economic, to plan development, and for them to spend such funds for the functions that would be devolved finally to them. So if the idea of federalism is to decentralize the functions of government, we already have the local government code. And this is the brainchild of Aquilino Pimentel, the father of Coco Pimentel. He was the one who spearheaded this decentralization and local autonomy. Now, as in federalism, I think the benefit of decentralization, once it is implemented, is that graft and corruption would be minimized, if not totally obliterated. Because what is happening now is that all the budgets are with the DBM, and it is the DBM that is releasing the funds under the decision of the Supreme Court. It is automatic. There is no more discretionary power, and the local government units are entitled as a matter of right to the automatic release of the internal revenue allotment and 40% of all the taxes collected by the national government. So I think there is a need for further discussions. Whether we will shift to federal form of government, or we can just improve the philosophy and idea and implementation of decentralization and local autonomy under the local government code, as explained by the Supreme Court in the twin cases of Mandanas and Garcia, and as further implemented and hastened by the Executive Order 138 issued by the President. Now, with all the character assassinations and political demolition jobs, I still believe that President Duterte has done a great deal of good for the Philippines. Recently, he liberalized the registration of land titles by increasing the area of pre-patent application by our poor farmers to 12 hectares. And not only that, shortening the period of continuous possession adverse to the public and the whole world in the concept of an owner from 30 years to only 20 years of such possession. Now, there are other improvements in the governance, like now it's very easy to get a passport, and for a longer period. Also, the driver's license has a longer period, except that really in the anomaly in the LTO, until now, I have not received the plate, the car plates for my car. Now, but I am here not to campaign or defend anybody. As a student or teacher of law, I am just saying that in this era of political campaign that has started yesterday, when Ping Lacson has already declared his candidacy for the president, and others were already gearing towards a campaign for the presidency, like Manny Pacquiao, Isko Moreno, and of course, Leni Robredo is only waiting on the wing. And we have already some rift in a major political party. Now, all these things will settle down. Maybe after the filing of the certificates of candidacy. So we will know in the political horse trading who will emerge to be the leader of the opposition and who will be the candidate of the administration. I just would like to advise or suggest to consider the qualifications of the candidates free from the political assassination or insulting demolition job. For example, I would prefer Harry Roque to be in the Senate. Also, Salvador Panelo to be in the Senate, because they are qualified to make laws. Harry Roque has been my co-professor at the UP College of Law. He has been in the forefront in public interest cases. He was a prosecutor in the massacre in Mindanao, and if I remember right, he was the complainant and the lawyer against Francisco Duque in the PhilHealth plunder. And even in the field of international law, he was in the Supreme Court on the issue of territorial dispute. If I remember correctly, he was the lawyer of another co-professor in UP on the baseline law justifying the group of islands theory in the South China Sea. He is a good international lawyer, and although he is the subject of a butt of jokes, he is still a very good lawyer who will be an asset in the Senate. In fact, before he got sick, I was already campaigning for him in the last senatorial election, but he got sick, and to his credit, for his patriotism and love of country, despite the fact that he was infected with the very debilitating and painful COVID-19, like me, also a survivor, he continued his duty as a spokesman. And I will vote for him. I will campaign for him. Also, for my classmate, Salvador Panelo, because he is a good lawyer. He was my co-professor in criminal law at the University of the East College of Law during the time of a friend who took us, Dean Amado Valdez, as his professor. I was teaching commercial law review and criminal law review. Secretary Panelo was teaching criminal law in the regular core subject, and he is well loved by our classmates. He was always a celebrity during class reunion, except that when he took his job as a presidential legal advisor, he rarely attended our class reunion. I was even laughing when somebody, out of anger, called him Panelong Butiki. So I said that he would go down in history as somebody who has been called Panelong Butiki. But despite that, he is a good lawyer. And when Anyway, let me not waste time on cases that we could have been handled together. But I would prefer Panelo in the Senate than actors who have not enacted any single law. And while Senator Pacquiao is a good boxer, he is not a good lawmaker. And I think that there is no need to be elected to a public office in order to do public service. Senator Pacquiao, if his heart bleeds for the poor, can help the poor. But one advice that I would like to caution him, he should not seek public office because his wife is extravagant, and this does not sit well with the poor people. He is pro-poor, but his wife spends too much, and you know, in the times of public acute wants, it is even I claim for damages to be extravagant under the civil code. Ostentatious display of wealth, like expensive bags and like sports car, that is even prohibited by the anti-poverty philosophy of the civil code, that it is even reprehensible to be ostentatious in the display of wealth during the period of public want, if his advocacy is for the poor. Now, he is distributing or giving away housing. Can he do that throughout the Philippines? Impossible. How can one win on the basis of a platform to give housing to everyone when that is a physical and economic impossibility? Now, I do not malign, or I do not object to his running for public office. This is a democracy. If he is elected by the people, the voice of the people is the voice of God. If the people want to elect him, he will be our president. Like Ramon Magsaysay, who, when his economic advisors told him that the problem of rising prices is due to the law of supply and demand, he ordered Congress to repeal the law of supply and demand. But credit to him, he is really pro-poor. He opened Malacanang on People's Day once a month, and he would let people whisper to him what they have in mind. But that is something that can be done by anybody. And as a matter of fact, right here in the city of Parañaque, we have People's Day every Monday and Tuesday, where our mayor, Edwin Olivares, is available to his constituents in Parañaque every Monday after the flag ceremony, and Tuesday he is available to be mixing with the common people And that's why we love him, because he really cares for the people, and he has acquired sufficient vaccines that vaccination is open in Parañaque, whether the patients are from Parañaque or not. We have an open vaccination program in Parañaque with American vaccines. So, before I go to another topic, last time we discussed revolutionary government. Now, that will endure and will be successful only if supported by the people and if supported by the military. As the lessons in revolutionary government during the Cory time has taught us. And that is even fraught with risk and dangers. During the time of Cory, there were many adventurism to topple her. But to the credit of Cory, she did not intend to stay long, and so she caused a commission to draft the 1986 Constitution, and it was ratified by the people. Now, it is an extraordinary, extra constitutional remedy that Cory resorted by amending the Constitution, and so doing, in order to hasten or expedite the process, she declared a revolutionary government. And once the Constitution was ratified by the people, then we were back to democracy. Now, let me just I recall that Secretary Drilon, well, Drilon is another politician who is highly qualified, and to my mind, he is more qualified than Tony Carpio to run for the presidency as the banner or presidential candidate for the Liberal Party, because he is a good lawyer. Drilon was only 1 year ahead of me in the UP College of Law. He was a campus politician and a columnist in the Philippine Collegian. He topped the bar, garnering third place in the 1969 bar examination. And he has wide experience in public service. He was Secretary of Labor, he was Secretary of Justice, and he was Senator. So he is a seasoned politician. And to me, he is more qualified than Tony Carpio. And he has the backing of the mighty and influential Sigma Rho fraternity. So he might yet win the presidency. And I believe that he is better qualified than Leni Robredo. Not that I am interfering in the caucus of the Liberal Party. That's their business. I am just exercising my freedom of expression, my right to free speech, and academic freedom, because we are now in the crossroad of history. So the people must be vigilant because it is our own destiny that is at stake. There is a saying that only fools do not change their mind. Depending on the supervening circumstances, in international law, there is a principle, rebus sic stantibus. And that is the same basis of the doctrine of the supervening event, that where there are facts and circumstances that happened after the final and executory decision of a court of law, under the tempering justice based on equity. A final and executory decision may be altered and modified to conform to the real facts, to serve the ends of justice. In the end, it is the paramount end of justice that is important. And as the saying of patriotic politicians goes, my loyalty to my party ends when my loyalty to my country begins. So we will see, and let us wait for the political realignment, both from the opposition and the administration, come the filing of the certificate of candidacy. It is possible that Isko Moreno might join as Vice President for Ping Lacson, or vice versa, to form a formidable opposition. And Leni Robredo, Pacquiao, and Tito Soto might just stay in the, or go back to the Senate. All things are possible under the sun. But anyway, let us wait and see. Before I leave this scenario, whether the election is postponed or not, there is going to be an election because we are a democratic country. And so in the election, I would like, and I will ask, and I will send queries to the leading candidates for my own consumption, so that I can make a public pronouncement of my preference among them as my academic right and right to free speech. And these are what I want the candidates for the top position of the country to have a platforms or programs of government. Number one, how to fight drugs addiction and smuggling. And of course, graft and corruption. I am very proud of my legacy, of my ancestors whose public service were untainted by any whip of graft and corruption. And I'm referring to Justice Roman Usaita. When he was the most senior justice of the Supreme Court, and Ricardo Parras was instead appointed by the President as Chief Justice. Justice Roman Usaita resigned as a matter of delicadeza because he was bypassed. And so he went into private practice, and he was even criticized by his distractor that he resigned in order to handle the battered case of Yulu Estate. When I say battered, more battered. But anyway, his public service is untainted by any graft and corruption. Then my other descendant, Justice Kirube Makalintal, Chief Justice of the Supreme Court and then Batasan Speaker during the time of Marcos. There was never any hint of graft and corruption during his public service. And we are protecting that. I have a relative here in the RTC of Parañaque, and I am very proud of him because he is considered very strict and very straight. And I am referring to Judge Pilimon Luna III, because his father was a protege of Chief Justice Makalintal and also retired as Court of Appeals Justice without any whip of corruption. And so I am very concerned also that graft and corruption, if minimized or checked, would lead to prosperity of our country, because graft and corruption has been with us. We inherited that from the Spaniards, because if you are a Catholic, to gain favor to the God the Father, you need a patron saint. You make a devotion so that your patron saint will intercede for you to the God the Father. And also, we inherited the system of graft and corruption from the Americans, where lobbying is allowed. To lobby for a consideration, horse trading is allowed. So that is part of the system that we inherited, but that can be minimized. And I believe that President Duterte has done his part to the very best of his ability to curb that, and to accuse him of graft and corruption, to my mind, without solid evidence, is the unkindest cut of all for what he has done for the country. And that is part of politics. Character assassination, demolition jobs, because that is part of the system in the political campaign. But let us let us not jump into conclusion that he is the mastermind and he is the most corrupt. Sapagkat ang aking pong paniniwala sa aking pagkakakilala sa kanya, ako po ay 15 taong nag-practice sa Davao City. Pinagpatayo ko ng bahay ang aking anak na nag-aral sa Ateneo Law School. At ako po naman ay hanggang ngayon ay may mga kaso pang hinahawakan doon. para sa Vitarich. Ang kliyente ko po ay isang dating anak ng ating dating senador, Francisco Soriano. Si Bobby Soriano po ang aking naging kliyente kung bakit ako napadpad sa Davao. At kami po naman ay malapit sa Davao dahil ang asawa ko po ay taga-Agusan sa Cabadbaran City sa Caraga Region. Kaya 3 oras lang buhat sa amin sa Cabadbaran. Ako ay nakakarating sa Davao. At talaga po na si Pangulong Duterte ay iginagalang, tinitingala ng mga tao, lalo na po ng mga negosyante at mga ordinaryong mamamayan. At siya po naman ay kinatatakutan ng mga masasamang loob na kanyang pinaalis at mga masasamang loob na hindi nanatili sa Davao habang siya ang nanunungkulan. Ang nangyayari po sa Senado na siya ay pinagbibintangan, na siya ang may hangad na yaman, na siya ang mastermind, ay isa pong bagay na sa akin pong paninindigan at conviction bilang abogado ay violation of due process. Due process hears before it condemns. It proceeds to trial and renders judgment only after trial. And let the evidence speak for itself on the guilt or innocence of the respondent. Ang nangyayari po ay inaakusahan agad na siya ang puno. At yan po ay dahil sa media. Atin pong alamin na hanggang ngayon ang ABS-CBN ay patuloy pong naninira sa pamahalaan. Samantalang ang ABS-CBN sa katotohanan ay tinotolerate na laang. Yan ho ay wala ng franchise. Dahil ang franchise po niyan ay pinutol na ng telecommunication. Ngayon, pinapayagan pa sila na doon sa iba naman nilang kumpanya na kasama naman sa mga inalisan ng franchise na makapagpatuloy dahil nagkaroon po ng isang pagkakamali na si Cory Aquino ay nakapag-issue ng executive order. Kahit tapos na yung franchise ay inaalaw yung subsidiary na dapat naman ay tinatawagan ko ng pansin ang telecommunication. Tingnan po ninyo ito sapagkat patuloy po ang ngaw at paninira ng ABS-CBN. At yan din po naman ang ginawa nila kay Marcos at kay GMA na talaga hong halimbawa si GMA kinikilala ko hong isang magaling na presidente. Si GMA po ay aking kinikilalang marunong na presidente, hands-on at napakasipag. Pero sinira po ng media at sinabi na corrupt. Ano-ano po ang napatunayan kay GMA? Ngayon, sa lahat na usapin ng graft and corruption, ako'y naniniwala na hindi corrupt si Duterte. Pero hindi ko po magagarantiyahan sa aking nalalaman ang mga tao na nakapaligid sa kanya. Kaya atin pong imbestigahan, atin pong usigin at usisain yung mga transaksyong iyan. At dapat po ay magkaroon ng batas. Ang sinisisi ko po siguro, mayroon ding dapat na gawin ang Kongreso na bakit halimbawa ay ang Statement of Assets and Liabilities ay ginagawang confidential, samantalang iyan po ay taliwas sa ligang batas na nag-uutos ng transparency, ay public office is a public trust, at iyan po ay kasama sa information on transactions of public concern. Dahil diyan po natin makikita ang graft and corruption. Ay bakit po naman itong ombudsman ay ina-apply yung right to privacy sa public officials who must be transparent and whose position is a public trust. Ay kaya po ako'y nagtataka bakit ang Kongreso, yan, ngayon, sina Ping Lacson, congressman, ay antimano ay sinasabi na graft and corruption. Ngayon, hindi ko sinusukatan ang kakayahan ni Ping Lacson na mamuno ng bayan dahil siya po ay veterano rin at siya po ay marunong, naging pulis. At matagal na rin naman ang naging tungkulan niya sa gobyerno. Pero noon pong sila ay nasa Kongreso, nung gawin po itong bayanihan to hail as one, ay mayroon pong nakalagay doon na binibigyan ng emergency power ang executive branch to respond to the pandemic, katulad ng pagbili ng mga kagamitan. Kaya hindi po kailangan diyan kung emergency power. Hindi po kailangan diyan ang public bidding dahil emergency nga po. Ngayon, hindi ko dinajustify si Christopher Lau. Dahil hindi naman dapat siyang mamili niyan dahil wala naman siyang nalalaman tungkol dyan. Dapat po si Duque. At yung pong kanyang pagka-transfer ng funds ay hindi po tama. 62 million? Maaaring siya honest, maaaring wala siyang kinuhang pera. Pero siya ay grossly negligent. Kung hindi man po intentional, ay grossly negligent. At saka he is spineless. Bakit hindi pa siya mag-resign dyan? Wala naman siyang nalalaman at wala naman siyang ginagawa. Napakatagal na niyan dyan. At ito namang pandemic na ito ay na-predict pa noong 2018. Nung magkaroon tayo ng flu pandemic dito. At nagkaroon na po ng batas ang ating Kongreso na sinasabing paghandaan ninyo ang pandemic. Wala pong ginawang paghahanda. At isa pa ngayon, ay bakit pinabayaan niyang mamili si Christopher Lau sa DBM pagkatapos doon siya bumibili na ubod ng mahal? O siyempre, kung ikaw ay dealer, ay di dapat kikita ka ng konti. Ngayon, sa lahat ng nangyayaring ito, ay wala namang patunay na ang nag-uutos nito ay si President Duterte, kaya unfair sa kanya. Kaya ang sinasabi ko dito ay marami pong nagawa ang presidente natin. Huwag naman ninyong masyadong siraan na sabihin ninyo na corrupt at pinalalabas ninyo na mastermind dahil siya po ay walang hangad sa yaman. Talastas ko po dahil ako ay 15 taon na nag-practice sa Davao. At siya po ay ginagalang ng lahat ng tao doon at wala hong korupsyon dahil you can finish your government transactions with the city of Davao in one day dahil yun ho ang sinabi niya. Pagka natapos ang maghapon, o nakailang araw at hindi pa kayo natatapos, magpunta kayo sa akin at tutulungan ko kayo. Ngayon sa akin, ang sinasabi ko lamang ay due process of law. At ito po naman ay magtatapos din kung magka-eleksyon, mapospon man o hindi, ay magtatapos din kung ano ang pulso at kung ano ang boses ng taong bayan. Ang taong bayan po ang masusunod. O ipagpatuloy po natin ang ating bar review. Nabanggit ko si Frank Trilon. Ay sinasabi po ni Frank Trilon na premeditated plunder ang nangyari. Di yun ho, ay kung hindi man sabihin, he is suggesting that the president is corrupt. Ay wala po namang ebidensya na puro suspicions and insinuations na ang mastermind sa ginawa ni Duque na 42 realigned budget ng Department of Health ibinigay at ibinalik sa DBM para ipamili ni Christopher Lau ng medical medical requirements, ay sinasabi ko pong yan ay talagang mali. Unconstitutional yan at yan ay illegal at immoral at maaari nga na may graft and corruption. Pero maaari pong hindi alam yan ni Presidente sa dami ng problema na hinaharap. Ay sino man ho ay matutuliro diyan. Kaya yan din po ang nangyari kay Gloria Macapagal Arroyo. Siya ang pinagbintangan na siya ang corrupt. Maaari hong corrupt people around, but not necessarily it goes necessarily to the top. Wala po namang ebidensya. Katulad din po nung sinisiraan si Ping Lacson sa Kuratong Baliling. Yan po namang usaping iyan ay na-clear na ng judiciary. Noon pong siya ay idimanda sa Kuratong Baliling sa RTC Quezon City kay Judge Yadaw. Ang isa pong co-accused, dahil si Ping Lacson po ay kaibigan ng aking law partner na naging judge, si Judge Totoy Jokno, ay pumunta sa akin dahil sabi, ikaw naman ang nag-originate ng Judicial Determination of Probable Cause na publish mo sa IBP Law Journal. Tulungan natin si Ping, bibigyan kita ng isang co-accused at yun ang i-represent mo. So nag-file kami ng Judicial Determination of Probable Cause. Now, ang suma total, napawalan sala si Ping. Ay, alam ninyo, ang politika talaga ay napakabigat dahil pwede kayong kasuhan kahit hindi totoo. Kaya ho, ang papasok sa politika ay kailangan may dibdib na bakal. Ngayon, mabalik ako kay Franklin Drilon. Sinabi niya na premeditated plunder. Ako ho, ay ang talagang portiko sa review ay criminal law. Dahil marami pong nahuhulog sa bar sa criminal law. Sa katotohanan nung 2017 na ako examiner sa commercial law, marami ang nadisgrasya sa bar dahil mahigpit ang naging bar examiner sa criminal law. Ang nakapasa yata sa kanya ay 16 o 18% at marami ang na-disqualified. Dahil pinakamahirap hong subject, yung criminal law. Dahil eksakto po ang sagot diyan. Ang laging tanong, what is the crime or crimes committed? At maikli ho lang naman ang subject ng criminal law, revised penal code, book 1 and 2, saka yung mga special penal laws. Napakaikli ho ang coverage. Kung ikukumpara ninyo sa commercial law, ang commercial law mayroon tayong old code of commerce, pagkatapos mayroon pang mga bulk sales law, transportation, insurance, corporation code, intellectual property code. Tatlo ho ang coverage. The laws on patent, trademark, and copyright. At mayroon tayo ngayong law on financial insolvency and rehabilitation. Yan po ang pumalit sa bankruptcy law or insolvency law. Pagkatapos meron tayong Central Bank Act, General Banking Act. Napakarami ho talaga ng coverage ng commercial law. At yung negotiable instruments, hindi ho nawawalaan ng question sa negotiable instrument in the form of a problem, either on forgery or whether an instrument is negotiable or not. Ay napakagulo po ng negotiable instruments law. Can you imagine the elements of negotiability? Dalawa lamang naman ang negotiable instruments. Promissory note and bill of exchange. Pero ang definition po ng promissory note andun sa likod ng batas, at hindi po organized ang negotiable instruments law. Kaya sa lecture ko, in 30 minutes po natatapos ko ang overview ng negotiable instruments law dahil in-rearrange ko po ang sequence, ni-reorganize ko ang negotiable instruments law dahil napakagulo ho. Ngayon, balik tayo sa criminal law. I have accepted a teaching assignment from my friend Dean Kitso of the Universidad de Manila. He was my co-counsel for some big corporations, and he is a very good friend of my wife, my son, who is now Undersecretary of the DITC. I have agreed to handle criminal law review for him. Ang pagtuturo ko po ng criminal law review, and if my prospective students are listening, ang inuuna ko po ay binibigyan ko sila ng outline ng definitions and concepts of the specific crimes defined in Book 2. Dahil po, mahirap maunawaan ang general principles in Book 1 of the Revised Penal Code kung walang adequate knowledge of the specific crimes defined in Book 2, to which the general principles like justifying, mitigating, aggravating circumstances are applied, and other general provisions, particularly aggravating circumstances. At tinatanggap ko po naman na ako'y magsusum at pakikiusap ko kay Dean Kitcho na i-open niya sa public, whether he will charge nominal fee for access or not, ay pag ako ang lecturer, ay gusto ko po ay open to the public. At sa University of Manila at sa PCU ay open po kami, hindi po kami nagcha-charge doon sa mga gustong makinig sa akin kahit ho sa pre-week. Now, going back to premeditated plunder, maari pong itanong ito sa bar sa November. At doon po sa dinidiscuss ko na the revised penal code, the provisions of the revised penal code apply to crimes punishable under the revised penal code called as mala in se. The provisions of the revised penal code, such as prescription, aggravating circumstances, do not apply to crimes punishable under special law like plunder. Plunder, although punishable under special law, is a mala in se crime, because even if it is not punishable under the RPC, it is inherently evil. But the rule on aggravating circumstance under Article 14, specifically the qualifying circumstance in murder of evident premeditation, does not apply to plunder, because plunder is a crime punishable by special law, the law on plunder. And where the imposable penalty, even under the revised penal code, is the single indivisible penalty of reclusion perpetua, 20 years and 1 day to 40 years. The presence of mitigating or aggravating circumstances are immaterial. Now, I do not blame Franklin Drilon. Maybe he has forgotten his criminal law. There is no such animal in criminal law as a crime of premeditated plunder, because the aggravating circumstance of evident premeditation does not apply to prosecution for plunder. No such animal as premeditated plunder. But then, the idea suggested by premeditated murder is that it goes to the top, and maybe it's a political gimmickry on the part of Senator Drilon, because I have told him one time, I think that it is written in the stars that someday you will become President of the Philippines. Not that I want you to remember me, but I can see that in my dreams. I was telling him that. And I'm sure he will remember, because he smiled although he did not say anything. Because we were together at the CSIP Salazar Law Office, and we have developed some kind of a brotherhood in law practice. I was even left at CSIP Salazar when he joined his friends in the Sigma Rho fraternity in another law firm of Joe Concepcion. But anyway, maybe you will remember when a question is asked whether there is premeditated murder as a crime. Now, the requirement for premeditated murder to be a qualifying circumstance for from homicide to murder is that it must be pinpointed or established when the decision to commit the crime took place, when the conspiracy was hatched, and sufficient time must have elapsed before the commission of the crime to prove that the offender clung to the decision or intention to commit the crime. Now, without that, there is no evident premeditation. How can you pinpoint evident premeditation, even assuming arguendo that the evident premeditation may be applicable to plunder, although it is not? There is absolutely no evidence. When the planning was started, and if sufficient time has elapsed to the time of execution or performance to produce the crime of plunder. Now, other platforms that I will be asking, I want the presidential candidates to explain what is their platform to solve insurgency. During the time of Ramon Magsaysay, he went to the hinterlands, to the mountains, and talked with the Huk Balahap, and he was able to convince Taruk to go down and join society. Now, what is the program of who may be the next president of the Republic of the Philippines to solve the problems, the perennial problems of insolvency that has been going on in the past 50 years, being waged by the new People's Army? And what is the platform of government to solve terrorism in Mindanao? We have already the decentralized Bansang Moro, and still the siege of Marawi took place. What is the platform of whoever is the next president to solve the Mindanao problem? I have been conducting similar pre-bar like this because I want more lawyers in Zamboanga, in Mindanao, to become lawyers so that they can help in formulating solutions to the perennial problems of terrorism in Mindanao. How to unite the warring factions among our Muslim brothers and achieve peace and integration to the national life among Filipinos with unity in diversity. And I believe when I gave my lecture to my brothers in Zamboanga that more lawyers will contribute to the efforts to solve the problem in Mindanao. I saw in the advertisement that Bangsang Moro is supporting Ping Lacson. We will know who are supporting whom when the campaign period opens. And again, I want the platform of the next president on economic development. I was a student of economics at the UP College of Economics, and I agree with my co-sabongero Manny Piñol that the catalyst to push economic development is agricultural production, because in most Asian countries that have overtaken us in economic development, they focused their attention to agricultural production, and that will push economic development. And that is the theory, really, among economists. Manny Piñol is critical about the policy of build. But you see, these two can go together, because you need farm-to-market roads in order to support agricultural production. So I do not know. Maybe it's a political pitch on the part of Manny, but I will vote for him because he is qualified to go to the Senate. But I do not believe that infrastructure development should take a back burner to agricultural production. They can go together simultaneously, because farm to market road is necessary, and infrastructure for irrigation and road building is really important in economic development, like irrigation, electrification. I am just wondering why my friend Jeff from the US, who is a supporter of Manny Piñol, is arguing and campaigning with anger against Duterte. He should not do that, because that is damaging the chances of Manny Piñol, who I believe deserves to be in the Senate. The old values of respect is still, I believe, something that we Filipinos cherish. We are lovers of the underdog. You see, the word is very long. Infra caninophile, that is lover of the underdog. We Filipinos are like that. Tayo ay para sa naaapi. At hindi natin gusto yung naninira na wala namang batayan. Tingnan ang ebidensya, kasi tayo ay nag-aaral ng batas, ating ipatupad ang batas. At katapos-tapusan na gusto kong itanong sa mga gustong mag-presidente ay ano ang stand sa South China Sea. At the start, maraming bansa ang humanga kay Pangulong Duterte because of his neutral foreign policy. That is a value in the Constitution to promote the amenity of nations. At merong isang political commentator sa Australia na sinasabi na magaling na diplomat si Presidente by going to China, going to Russia to promote amity of nations and neutrality in foreign policy. Ngayon, maraming mga Pilipino ang sinasabi na ang policy sa South China Sea of neutrality ay hindi maganda kasi tayo ay nabubuli at tayo ay takot sa China. Ay kung tayo ba ay lalaban sa China nang hindi tayo tutulungan ng Amerika, ay di pupulbusin lang tayo. At kung hindi naman nag-neutral policy si Presidente sa South China Sea, hindi naman tayo papansinin ng Amerika dahil ako po ay matagal na tumira sa Amerika. Ako ay nag-aaral sa Amerika. Ang anak ko, pinapag-aral ko lahat sa Amerika at ginastusan ko para sila ay magkaroon ng doctoral degree sa Amerika. Ay, ang discrimination po naman doon ay hanggang ngayon ay naririyan pa at saka hindi nga tayo papansinin kung hindi tayo nag-neutral foreign policy. I am for neutral foreign policy adopted by the President. Kung hindi po, aapihin tayo ng Amerika. But kailangan din po natin ang Amerika. Pero dapat, based on mutual standing and mutual respect for mutual benefits dahil kung kailangan po natin ang Amerika para sa depensa ng ating bansa, kailangan din po naman ng Amerika ang Pilipinas para sa balance of power sa South China Sea. Dahil kung mananatili po na ipagpapatuloy ng China ang pamamayagpag at tuluyan na nilang aangkinin ang South China Sea, including the high seas and the exclusive economic zones of the Philippines, ay ang mapiperwisyo po ay hindi lamang ang Pilipinas, kundi ang buong bansa, ang buong sanlibutan, the countries of the world. Kasi po ay doon dumadaan ang trade and commerce ng lahat ng bansa ng Pilipinas at iyan po ang pinangangalagaan ng public international law because the high seas belong to mankind. Hindi po pwede na angkinin ng isang bansa lamang. Yan po ang tinatawag sa international law na res nullius. It belongs to humanity. At yung po namang exclusive economic zone, it belongs to us. It is our sovereign right to exploit the marine and natural resources there. Ngayon, ang debate rito, dahil nagkaroon ng panahon ni Gloria Macapagal Arroyo ng joint venture para i-develop yan. Ang sinasabi po ni Tony Carpio ay that belongs exclusively to the Filipino. Hindi pwede ang joint venture. Ako po ay hindi naniniwala sa posisyong iyan dahil the definition of a Filipino entitled to the development, exploitation, and utilization of natural resources is well defined by law. A 60-40 corporation, meaning 60% owned Filipino and 40% owned foreigner. On common shares that are voting and controlling qualifies as a Filipino. Philippine corporation is equivalent to a Filipino. That is under the Foreign Investment Act as defined by law. Ngayon, ang talagang maraming itinanong na amin namang nahulaan ay nung yung Gamboa versus Tevez ay ilabas ng Supreme Court na ang 60% Filipino-owned ay dapat sa voting shares at dapat ay sa preferred or non-voting shares. At ang 40% foreign equity investment must be computed yun ang foreigner, doon lang limited ang foreigner. And yan po ang nangyari kung bakit ang ABS-CBN ay nasaraduhan. Dahil ang ABS-CBN, ang ginagamit na pundo were solicited from foreign investments. At ang ginawa po nila to go around the constitutional requirement that media may be operated only by 100% Filipino capital. Ang ginawa po nila ay nagtayo ng subsidiary at doon po tumatanggap ng foreign investments na tinatawag na Philippine Deposit Certificates. At yung pong Philippine Deposit Certificates, ang dividends or income are based on the operations of ABS-CBN. Oh, ay di, to our mind, what cannot be done directly cannot be done indirectly. So, ang ABS-CBN po ay kontrolado ng foreigner dahil ang pundong ginagamit nila ay foreign investments. At yan po naman, if we will go to history, yan ang ikinatapol ni never mind. Let me not go to history anymore. Pero yan po ang dahilan kung bakit ang prangkisa ng ABS-CBN ay hindi na-renew. Ngayon, naputol na ang prangkisang yan, nag-expire na, hindi naman nila ni-renew kasi malakas sila kay Cory dahil yung Meralco ibinalik sa kanila, wala naman silang binayaran. Samantalang yung Meralco po ay kinuha ni Marcos dahil hindi makabayad ng napakalaking utang si Lopez. Pagkatapos ngayon, nung Cory administration, nihaw-niho, walang dokumento, ibinalik lang ng PCGG kay Lopez. Ay samantalang yan naman kinuha ng Marcos government bayad sa utang. Malaking utang ni Lopez na hindi naman nabayaran. Hindi na rin binayaran yon. Kaya ngayon, hanggang ngayon, yan ay dapat issue pa. So, yung sa South China Sea, dapat malaman kung ano ang stand dahil interesado po ang mamamayang Pilipino, lalo na po yung mga abogado at lalo na po yung narito sa National Capital Region dahil yan po ang issue na nire-raise ni Tony Carpio as former Supreme Court Justice. Kahit po naman ako ay may disagreement sa kanya, siya naman ay kinikilala ko na qualified at marunong. Dahil yan po ay valedictorian sa UP, si Tony Carpio. And leader, siya ang Grand Archon ng kanilang fraternity. Mayroon pong distinction tayong Kristiyano, you may condemn the act, but not the actor. Maaring you disagree with the acts or with the policy, but you respect the actor. At nakikita lamang po ang tunay na karakter ng isang tao pag siya ay nagagalit. Na kahit nga tayo ay nagagalit, kung tayo ay may respeto sa ating kinagagalitan, dahan-dahan po tayo dahil importante po ang respeto sa kapwa para tayo naman ay irespeto rin. Dahil pong nobody is perfect. We have to choose the leader, lalo na po sa presidente na talagang nakakagawa ng mabuti sa bayan. Maari po na meron tayong hindi nagugustuhan, dapat po nating maintindihan na kung ano po ang nagagawang mabuti, ay iyon ang dapat na mas mahalaga. Mayroon nga hong nagmumura pero mabait naman. Ang kalooban naman kung minsan pagkakaraiwala, lalo ho kung nagagalit, talaga hong ganyan. Dahil sa mundong ito, there is no perfect person. Kaya po nung ito kwento ho, 10:30 para naman ang concentration ninyo ay huwag masyadong mapagod. Jokes muna po, jokes. Pag ako po ay nag-lecture sa mandatory legal education at nakikita ko na medyo inaantok, mayroong talagang nakakatulog, ako po ay nagdo-jokes. So, minsan, ako ay nagli-lecture sa mandatory legal education sa IBP, doon sa Pasig. So, sabi ko, mayroong isang abogado na nagpunta sa psychologist. Sabi niya, ako doktor, ay hindi makatulog sa gabi. Ay bakit? Anong iniisip mo? Yun hong mga troubles ko, lagi ko hong naiisip sa gabi. Ganito ang gawin mo para ikay makatulog. Do not take your troubles to bed. O sige, doktor, gagawin ko. So, nung umuwi, ang pasyente sa bahay, time to sleep, yung asawa pinatulog sa sahig. Sabi ni Doc, do not take your troubles to bed. Diyan ka matulog. Ngayon, ikinukwento ko yan, yung dalawa kong kaklase na nag-a-attend ng mandatory legal education, ang sabi, isusumbong kita kay Sol. Bakit ganyan ang biro mo? Isusumbong kita. Alam nyo, hindi niya alam na yung asawa ko ando sa pinto, nakasilip, nakikinig. Dahil ako po naman ay naiintindihan ng aking asawa. Siya ho ay malaki ang pasensya sa aking mga biro at sa aking mga pagkukulang. Dahil po nung ako mag-propose ng marriage sa kanya, natatandaan ko sa Sulu Hotel sa Quezon City, sinabi ko sa kanya, I have many faults and imperfections. Ako ay hot-headed, ako ay temperamental, ako ay biglain, at I am brutally frank. Kaya maraming tao ang galit sa akin. But one thing I can tell you, insincerity and dishonesty is not one of them. I am loyal to my friends, and I am sincere and true. There is no perfect persons in this world except perfecto. And then she said, my father is perfecto. Then your father is perfect only by name. We got married, and the first child born to us was named Perfecto Arturo de Castro. He is the only child of us that is not a lawyer, because he did not want to be a lawyer. When I was forcing him to take up law, I enrolled him in the UP Bachelor of Arts, but then he ran away from home because he said, I do not want to be a lawyer. I will never become a lawyer. I want to be a musician. So he left, and he was teaching already music in the Yamaha Sound of Music. So I searched him. I saw him in an apartment. There is no air conditioning. It's very modest, and so I told him, son, you come home. I'm sorry for forcing you to take up law. You can pursue whatever you want. Just be good in what you want to be. Be the best in what you want to be. So he came home, and he was the solo guitarist of the River Maya. And from UP, he transferred to Women's University, where there is a good music school, and finished his Bachelor of Music there, got married, and went to the United States. Now, he is very caring to us, and we are very proud to have him. Before the pandemic, he would come here and do concert with former members of his band, River Maya. And he was the one who told me that in the review you advise your students not to waste time on doctrines or portions of the review that they already know. Just concentrate on what they tend to forget. And siguro mana sa nanay, magaling din naman ang ulo. He can play all the classical musics from memory. Let us have, now we have already reached the half mark. It's already 10:35. Let us have a 3 minutes, and I will organize the topic for the remaining lecture. Break for 3 minutes only. Iinom ako ng tubig.
Isa pa.
Let's continue. Hello? Shall we continue? I hope that you read the twin cases of Mandanas and Garcia. I cited the GRL number, which you can read online, and also Executive Order 138. Now, in this case, Ted Garcia, congressman from Bataan, filed a case against the executive secretary on the implementation of the local government code, and which is actually also an implementation of the constitutional provision on decentralization and local autonomy in favor of local government units implemented by the local government code, and by a specific implementing law giving giving the local government, in the in addition to internal revenue allotment, 40% starting 2022 under the executive order. Local government unit will be entitled to 40% of all the national taxes collected by the national government. And the reason for this, in answer to the Macbar question, is to enable the local government to fund the services and functions devolved from the national government to the local government, including construction of hospitals and other allied services. Now, this is to take effect in next year, 2022. That's why many candidates are interested to be governors. Can you imagine? In addition to local earnings or local taxes, real estate taxes, local government units would be entitled to 40% of all the national taxes collected by the government. The controversy was expounded by the computation of the 40% made by the national government, excluding customs duties and other national taxes, by interpreting and actually amending the provision of the law. 40% of all national taxes, it was interpreted to mean only all internal revenue taxes. So that would include customs duties and taxes on minerals and other taxes, including the tax. I think it's 1% or 2% paid to the Commission on Audit for services, audit services rendered to government institutions. The complaint or the petition filed by Ted Garcia was for mandamus. The other case filed by Governor Mandanas is for certiorari. Actually, before Governor Mandanas before Governor Mandanas filed the case, he called me. He was retaining me to file the case. Unfortunately, at that time, I was about to leave for the United States to visit my grandchildren and to buy roosters in America. So I was not able to handle the case for him. So he got another lawyer and filed the case. Now the petition of Governor Mandanas has the same cause of action: unconstitutional implementation, reducing the 40% to just the internal revenue taxes collected by the national government, excluding customs duties and other taxes collected by the national government. On the procedural issue, the first hurdle in the Garcia petition is whether mandamus will lie to compel the national government to correct the interpretation of national taxes. The Supreme Court held that mandamus will not lie to compel a duty which is discretionary in nature, meaning not specifically enjoined by law, because the right to compute is discretionary, and if it is computed wrongly, you cannot compel by mandamus the national government, specifically the executive secretary, to do the correction, because it is not a duty specifically enjoined by law. However, what is controlling is the cause of action pleaded in the body of the petition. And while it is wrongly captioned as mandamus, in reality, it is actually a petition for certiorari to declare null and void the interpretation and computation by the national government, excluding other taxes from what is clear national taxes, and applying the rule of verba legis. The Supreme Court held that it is unconstitutional to compute the 40% from the all national taxes collected by the national government, to limit it to internal revenue taxes and exclude customs duties and other taxes. And even the tax in favor of COA, very, very minimal, for services rendered for auditing government offices, is included in the 40%, and other taxes. The only exception is excluded are taxes that are levied for a specific purpose. That is special taxes that are levied for a specific purpose. So, national taxes in its ordinary signification includes all national taxes collected by the national government, and the LGUs are entitled to 40% of that, with the exception, I repeat, of taxes levied for special purposes or special taxes. Now, let us go to online. Are the LGUs entitled to 40% of the multi-billion taxes generated by PAGCOR from online operators? The collection of PAGCOR for every online operator is 12,500 per fight, and the minimum requirement a day for a particular online operator is at least 200 fights, and the online operator is being taxed 200 times 12,500 minimum each day. But if the number of fights of an operator online cannot meet 200 fights, the online operator has to pay for 200 fights. And if the online operator cannot meet that, then it will lose money. To be profitable, the minimum number of fights that must be achieved is 250 to 300. And Atong Ang, with his better management and better experience, can achieve as many as 400 fights, 300 to 400 fights. That's why it's very profitable for him. And he has online betting system that is in place. Question. So PAGCOR is earning multi-billion from operation, and can you imagine the cost of one day operation of just one would be approximately 300 million just for one day. And to earn, to make money on such very costly fund support, every every online cockfight must have at least 600 bets. That is left and right added, because even the Dihado and the Llamado are both being taxed with Plazada. Now, if a new comer cannot meet that, it would be very difficult to survive in online sabong. But there are many online operators that are in operation now. Only we do not know who will survive and who will not. And as far as PAGCOR is concerned, as a matter of equal protection of the law, equal opportunity, anybody who wants to go online sabong will be given PAGCOR permit, provided that there is a license granted by the local government unit, because under the local government code, the permit to operate sabong, to establish cockfights and to allow to establish cockpits and to allow cockfights, the authority is given to the local city or municipal council. The resolution is under the local government code is sent to the provincial board, reviewable by the provincial board, but there is a deadline. If it is not acted upon within a certain period of time, then it is deemed approved. But where a denial is appealed, then the provincial board will have to resolve the issue. And that's why the government units, being the authority that can grant cockpit license, must interpose no objection to PAGCOR, to the operation of online sabong. So, and then just recently, there is another online operator, Jade, I just do not know which group is this, has been granted a PAGCOR license. In addition to Atong Ang of the PWC, Pitmaster Group. We have the Encuentro Group of Patrick Antonio, and there are others who are operating sabong, and that is open as a matter of due process. But the reality is only people with money can embark on online sabong, because the bond required is 75 million, and the cost, whether it is a tax or a license fee per fight, is 12,500, and you multiply that by 200. And the other charges, the rental to the cockpit, and the allowances to the derby participants. The minimum requirement, capital requirement, is 300 million. But you see, you can bring it down. There is a way of bringing it down. But anyway, that is not purely legal. That is a management aspect, which I did not discuss that here. But the distinction between a license fee and a tax is that a tax is intended to raise revenue, and there is no limit to the taxing power, such that the power to tax is considered a power to destroy, because if a business is taxed so high, it has the ultimate effect of destroying the business. Now, on the other hand, a license fee under established jurisprudence is limited only to the cost, overhead cost of regulation. But since PAGCOR is collecting more than is necessary to regulate online sabong, then the collection of the PAGCOR as an agency of the national government is in effect and in reality a tax, because it is intended to raise revenue. And as admitted by no less than the President, he is apologizing to the nation to resorting to tolerating gambling so he can raise money, and therefore that makes the PAGCOR collection a revenue matter, and therefore a tax. And ergo, the local government is entitled to 40% of that. And being a collection of the national government, COA should watch over that, because COA is the guardian of public funds. That is the constitutional function of COA, because no public funds may be disbursed except for public purpose as allocated by Congress. I do not know if this is an intermission or an advice to prospective lawyers. Let us go to legal ethics. The law profession is not a business. Its purpose and function is to serve the administration of justice. So that is a distinction between the legal profession, which is supposed to be a noble one, and a business enterprise. But you have to be charitable to yourself. Financial stability is a natural consequence of success. You can earn in law practice honestly and properly. The best way to make an agreement on the legal fees is at the start. You see, if a client is wanted, a warrant of arrest has been issued, comes to you in the middle of the night, knock at your door, and he wants to retain you, that is the best time to forge an agreement on the legal fees. Do not embark into a difficult case without an agreement, because later on, when you have won the case, murang-mura na nga ang sinisingil mo, tatawaran ka pa, kung minsan hindi ka pa babayaran. And even if money has come to you and there is no agreement on the fees, you cannot dip into your hands on such money without the consent of the client. But you can deduct from your monetary recovery if there is a written agreement and you are authorized to deduct, particularly in contingency fee agreement, because the Supreme Court is very strict. I have a friend in Davao who settled amicably a case. On the first installment, he appropriated the money received and applied it to his legal fees. The Supreme Court suspended him for 6 months. He filed a motion for reconsideration, arguing that he deserved what he got. And the Supreme Court increased the suspension to 2 years. And I told him, do not file a motion for reconsideration anymore. You withdraw your motion for reconsideration. You apologize, and you beg to reinstate the 6 months period. But anyway, that is how strict the Supreme Court on matters of money. If I were an examiner, I will ask, may a lawyer sue his client for non-payment of attorney's fees on a case that is favorably decided in his favor, in favor of the client? This is the answer. As a general rule, the lawyer should not be able to sue the client. The only exception is to prevent an imposition. And you will read that. I summarized the ruling of the Supreme Court in my digest of leading cases. So to prevent imposition, and the meaning of that is to avoid fraud, unjust enrichment. That is the meaning of imposition. I have never sued a client. I just charged it to experience. But then I learned that the best way to be charitable to yourself as a practicing lawyer, there is a saying, if so smart, why so poor? Because a lawyer probably has not been charitable to himself. Because if you will allow the client to fix it at the end of the engagement, you have won the case, hindi ka pa mabayaran, at parang ikaw pa ang nagmamakaawa na ikaw ay bayaran. Hindi mo naman maidemanda. Masama din naman ang impression kung nagdemanda ka, hindi maganda, matatakot ang mga kliyente sa iyo. That's why ang advice ko sa mga kaibigan ko, huwag kayong magpapahiram ng pera sa judge, sa piskal at sa prosecutor at sa pulis, dahil pag hindi ka na mabayaran at siningil mo, ikaw pa ang ihahabla. Kaya lawyers, prosecutors, judges are not good borrowers. It is not a crime to be rich. Hindi tayo dapat magalit o mainggit doon sa mga mayayaman. Lalo na kung ang kayamanan ay pinaghirapan. Mayroong akong nabasa na Rockefeller became very rich because his wife was a spendthrift. Gastadora ang asawa niya. Kaya maituloy ko ang kwento nung mag-propose ako sa misis ko sa Sulu Hotel. Marami na siguro kaming nainom noon at ako medyo lasing na. Hindi naman ako nagyayabang pero sinabi ko, I'm going to work hard to earn money so much that you cannot spend the rest of your life. That is my promise to you. Ano naman, hindi naman siguro niniwala kasi sinabi ko, ako wala akong pera. Ako maraming utang kasi marami akong utang totoo naman, marami akong utang sa opisina dahil ako'y natatalo sa sabong. Kung minsan nga, dadating yung handler ko dito sa Manila, may dalang manok, dadaanan ako sa opisina, iniikot namin ang sabungan dyan sa Marikina, San Mateo, sina Bandilion pa ang nakakalaban namin. Siyempre, ako na may pinauutang ni Liliang, malaki ang utang ko sa opisina. Kaya sinabi ko, ako'y walang pera, pero pinapangako ko sa iyo, kung ako'y mapapangasawa mo, I will work hard para ako ay kumita ng pera sa marangal na paraan na hindi mo kayang ubusin habang ikaw ay nabubuhay. Yan ang tanda ng aking pagmamahal na ipinangangako ko sa iyo. Dahil ako'y walang pera ngayon. Ako'y mautang. At saka sabi ko, hindi ko naman sinasabi na ako'y sagutin mo. Tingnan mo kung kita'y magkakasundo at it works both ways. Tingnan ko kung talagang ikaw ay magugustuhan ko. Dahil ang gusto ko, yun talagang gusto ko. Na paggising ko sa umaga, kahit na anong problema ay gusto ko at kahit na anong ugali mo, kung gusto kita, ano man ang mangyari. So, yun ang nangyari. We got married. Ngayon, anong nangyari sa aking pangako? Hindi pa ho natutupad hanggang ngayon. But I'm still trying to earn my living honestly. We still have time. Ang tatalakayin ko naman ngayon, let us start with political law and public international law. Kung itanong sa inyo, what is the power of impoundment of the President? Ay kung minsan tinatanong yan for 2, 3 points, o minsan 1 point. Power of impoundment. It is the power of the President not to spend the funds allocated for the President by Congress. That is the power of impoundment. Pero yan ay dapat sinadya. Kung napabayaan laang. Kamukha naman ng nangyari kay Francisco Duque. May mga hindi ginamit na pera. Hindi yan power of impoundment by the executive. That is gross negligence ni Duque. The power of impoundment is the power of the executive not to spend the money allocated. Eh di sila dyan, hindi gastusin. Baka hindi kailangan o baka hindi tama. Ngayon, kung gusto ninyong makita, mabasa yung kaso where that is discussed, let me see. O, basahin nyo yung page 11 ng aking Green Study Guide. Ito. At kung doon sa hindi nakapakinig ng speed reading, memorization skills, and how to take down notes, and how to listen to lecture, yun ang first chapter nito. At isa sa inyo, isang estudyante ko na kaibigan ko ang meron nito, binigyan ko. Pwede naman ninyo itong ipa-xerox. I allow you, because I'm the owner of the copyright, I allow you to xerox this for your own use. If it is not for commercial use, there is no violation of copyright. And anyway, I'm the copyright owner. Yun, yung power of impoundment, page 11 nito. Wala pang itinatanong, in the area of land registration, on the concept of what is a native title. A native title is the title recognized by the government in favor of indigenous people who have been in the area in their ancestral domain since time immemorial, even before the conquest of the Spaniards in 1521. And this title is recognized even without registration. Although registration may be formally made, but there is no need for such registration, for as long as it is determined to be an ancestral domain where the indigenous people have lived generations after generations. They are entitled to the ownership of this land. No question has so far been asked on that. Now, on what is a native title, you can read it. Let me see. It is in the section of this Green Study Guide on political law. Now, election is part of the bar examination in political law. And I want you to consider the party list. What is the concept of the party list? And May a political party be entitled to a party list representative? The answer is yes. As long as a political party represent the marginalized sector of society. Now, registration of a party list would require that you have branches or offices in the 12 regions. And to be elected and to be qualified, we are about we have only about let me see 60 minutes. I will just encourage you to read my study guide for the bar. Now, what I plan to do is I will publish this on my own. I will just pay for reprinting because in 2009 I revised my book, Study Guide for the Bar, Criminal Law Reviewer on Special Penal Laws, published by the Rex Bookstore. I was told that I had something about 30,000 in check in royalty, which I wasn't able to get. Now, I sent my manuscript of this study guide, revised, to them by email. They did not print it because at that time, the owner, Mr. Pontilera, was already dead. I did not get my royalty. And the unkindest cut of all, I was told that they will burn my books because nobody is buying it. And so I told them, I will send somebody to pick them up so I can give them to my students. My students love them. Why would you say that you will burn or throw them away? Give them to me. They did not give it to me, but I know that they are doing some sale, so I got mad and I stopped my publication. Now I have decided to make a reprint and make an update on my own. I will print it myself. But in the meantime, as I have been doing it in the pre-bar review, where I'm doing bar review, I put my updates in the Dean's office, and it is open to students and reviewers from other school. All they have to do is pay the Xerox cost to the Dean's office of the UM and PCU. I continue to teach in PCU, where they still consider me a bar review director. And of course, I have transferred to the University of Manila, where I have been appointed Dean of the College of Criminology, and concurrently initially Vice Dean of the College of Law, until I was promoted about 2-3 years ago to Dean, full Dean of the graduate school. But I continue my updates, and when I'm invited, for example, in UST and in other school, then I gave pre-week lectures. So that is what I plan to do. In the meantime that I am organizing my reprint and publication, I will make available the manuscript of my study guide. Oh, let us continue. Freedom of religion. Pacquiao is asking, no, not asking, not Pacquiao. Actually, it was Davila in the interview. What kinds of cases are you going to file against Pastor Kibuloy? And Pacquiao, not knowing what cases to file, said, I will announce that when I file it. He has not filed it until now. So, I have a suggestion. Maybe an injunction suit against him not to meddle in politics because of separation of the church and the state. But is there a provision in the Constitution on the separation of the church and the state? There is none. It is only in the decisions of the Supreme Court. What is provided by the Constitution is freedom of religion, which must be respected. And a student who refuses to salute the flag and who refuses to sing the national anthem because it is contrary to his religious beliefs cannot be compelled to do that because he has freedom of religion, and which is the freedom that must be respected with respect to his religious beliefs. There is no provision in the Constitution on separation of church and the state, but there are many decisions that the church cannot meddle on political affairs of government. One such example, a clergy cannot run for public office. And there is a decision, you cannot register a political party that represents a religious organization. And so what is the meaning of that? There is separation of the church and the state. While Kibuloy has the freedom of religion, he cannot meddle in politics. And it would be a noble petition to file not a prohibition but an injunction against him. And I am suggesting that to Pacquiao. I'm willing to handle that for free if he will allow me. Because when Kibuloy said that Pacquiao is guilty of graft and corruption in the construction of a sports center, Pacquiao announced to the public in his public interview with Davila that Kibuloy acted with malice because he posted the picture of an old dilapidated sports center, which is not his sports center, which is finished with a budget of 300 million to 500 million, and the 3.5 billion project is the project of Senator Christopher Bungo. That's what Pacquiao said. Again, Pacquiao has to prove that, because if that is not true, that is damaging to another candidate being groomed for the presidency. That is very damaging. Can you imagine Pacquiao making accusation without evidence? But anyway, it's the political season. And so we are interested to know, is it true that there is a project by Senator Christopher Bungu with a budget of 3.5 billion, which by suggestion of Pacquiao is tainted with graft and corruption, although he did not say that directly. But of course, that is what he is suggesting. Again, still in constitutional law, custodial interrogation. What are the requirements for custodial interrogation? There is a special law, RA 7438, governing custodial interrogation. And what is important in the protocol, where there is a warrant of arrest and the police would arrest a person, he should read the Miranda warning. You have the right to remain silent. Anything you would say will be used against you in a court of law. You have the right to competent counsel. Well, at least the Miranda ruling would give the warning of the right to remain silent and to apprise him of his constitutional right. Without that, the arrest is illegal, assuming that there is probable cause. Now, in the SAPLA decision, the Supreme Court in a 2018 decision very strictly construed the requirement of probable cause. Whereas before, a tipped information is sufficient to make an arrest. It was reversed in the SAPLA decision in 2018. In that case, somebody called the police station. There is somebody who is trading in marijuana, making the description and making the bag where the marijuana is contained, and describing the bus that he boarded. And what the police did, based on tipped telephone information, was to put a checkpoint. And here came the bus fitting the description, and right away the police officer boarded the bus and saw the guy described by the informant. And the police, seeing the description of the bag, got the bag and arrested the person. Is there probable cause based on tipped information? The answer of the Supreme Court is no. Because in addition to tipped information, the police is duty-bound to make a surveillance, to make an investigation, and gather facts and gather evidence showing facts and circumstances that a crime has been committed or is being committed, and the person to be arrested is the author of the crime. all prior decisions saying that tip information is sufficient probable cause has been abandoned and reversed by the SAPLA decision. And I think that this is very material because not all the police officers are apprised of that, of this. When I was a lecturer in the UP Law Center and the PNP would ask for a lecturer, I would be sent by the Law Center because I have a module on the police protocols on serving warrant of arrest, and then what are the circumstances when warrantless searches and seizures may be effected. So I would explain that. And but now, even in my hometown in San Jose, when the judge was the husband of a nephew or a niece in the Usaita family, Justice Judge Castillo, every now and then he would ask me to give pre-lectures on police protocols under the police manual in the implementation of warrants of arrest and protocols on drugs cases. And but then the police officers in San Jose, Batangas do not even know the law. Can you imagine? I was telling them, under the revised rules of criminal procedure, under the recent amendments, where the crime has a penalty not exceeding 4 years, 2 months, and 1 day, the police can already file a case directly with the court, and the complainant can file directly with the court. But then what happened in simple case of violation of wetting, tupada, which carry a very slight penalty, it would take the investigator in the police department several days before they file the case with the fiscal's office, and the fiscal's office, when the case is filed, is already past the limit for arbitrary detention under the revised penal code. So they are guilty of arbitrary detention. When under the procedure, they can file the case directly. And then my handler was suspected of murder or homicide. On the information or on the evidence, nothing more, nothing less, that his tricycle is suspected to be used when there is no evidence positively pointing to him as the gunman, or there is absolutely no evidence that he was present when the crime took place. And what did the investigator do? He impounded the tricycle in the house of the suspect. How can they impound it when there is no case and there is no probable cause for a search and seizure? And so I went there and I was asking for a copy of the complaint, and because that's the information that I got. And the investigator, Kuliyat, who investigated the case and who talked to us said that I will give you a copy after I file this with the fiscal's office. But why do you file that right away without due process, without giving us a chance? I will file a counter affidavit. If you want, I will bring the suspect tomorrow here. But you were there out to arrest him already when you impounded the tricycle. You know, tricycle looks like every tricycle. And without facts and circumstances indicating that the person to be arrested is the author of the crime, and without that, one cannot just make a warrantless search and seizure of the tricycle. The tricycle does not belong to my handler. It belongs to a brother who is working abroad. So I asked my my handler, go back and work because I did you there. We have a fight in Pitmaster. But he was afraid because there was an attempt to arrest him when the tricycle was taken, and so I said, why don't you make an investigation, and if you do not have probable cause, you please read SAPLA versus Court of Appeals on probable cause, which apparently you do not know. And then he said, I will check it with my superior. And that is the trouble with that police officer, with that police station. Nobody is in charge. They will still have to ask the superior, who is not around most of the time. If I would be the mayor, I would have them, if not sacked, transferred to Tawi-Tawi. Because that they are doing a disservice, they are violating due process of law. So, all right, why can I not be given a copy of the complaint that would be filed with the fiscal's office when I am asking? You do the investigation here, I will present my handler, and we will submit counter affidavit, and then you decide. You cannot make an arrest. If you succeeded in arresting him, you would have conducted an illegal arrest for lack of probable cause. But let me see the evidence. What is your evidence? But I said, I will check it with the superior, and that is the problem. There should be somebody in charge who would decide, who can decide. Well, I am... No, let me just finish it before I continue about the problems in San Jose, Batangas. Let me just wind it up. The right to bail. Bail cannot be applied with the inferior court where the crime falls within the jurisdiction of the regional trial court. So the priority is this: where the accused who has been issued a warrant of arrest can go to the regional trial court that issues the warrant of arrest, then he can apply for bail there in the issuing regional trial court, where the issuing court is not available. Then go to another branch of the same RTC. It is only when there is no branch of the RTC that is available to consider the application for bail that the accused may go to the city or municipal trial court and apply for bail there. Now, if the accused is in some other jurisdiction and cannot go to the issuing court, then he may surrender to the chief of police, so that the to the police station, so that the police station may bring him to the regional trial court so he can apply for bail there. Now, in another jurisdiction, without a certificate of detention, he cannot be granted bail. If he applies for bail there, the judge will, in other jurisdiction, the judge will require him to get a certificate of detention, because you cannot grant a bail to somebody who is at large. And when the RTC in the place where he is applying for bail is not available, that's the only time that he can go to the lower court, to the inferior court. Now, this is a trick that is not known to practitioners. I learned this from seasoned practitioner, where your client is a detention prisoner, and he will be and for example, he waived the arbitrary detention. There is no case yet. You can file an application for bail in the court of proper jurisdiction. And what is the advantage of that? Where a case has already been filed, or rather an information has been filed following the inquest, it is the prosecution, when you apply for bail, that will be presenting evidence to prove that the evidence of guilt is strong. The procedure is reversed if the information has not been filed and you file a petition for bail. The applicant for bail is the one presenting evidence, and that is the distinction and the difference there. And of course, the prosecution may oppose, but then the judge has the leeway. After hearing the applicant, may grant bail. And that was the practice that has been adopted a long time ago, which I learned from old-time lawyers. Now, where a crime is committed in the United States, and the crime is extraditable, like the case of Crispo, the one who bought the bulletin today, indicted in the United States, the U.S. Department of State filed a case for extradition here. And the issue is a case subject to extradition of an accused in the United States who has been arrested here under an extradition case filed by the U.S. Department of Justice through the Department of Justice, entitled to bail. When the Crispo case took place, the ruling is that extradition is neither criminal nor a civil case, and therefore the provision of the Constitution does not apply on the right to bail. Now, the person to be arrested was a Filipino national, accused in the United States of making illegal donation to the Clinton campaign. And so that was the ruling. But then the Supreme Court problem with Ding, may problema.
No. Okay lang. Just continue, Daddy.
Cannot connect eh.
No. Just continue. Continue lang, Daddy.
But so that was the ruling at that time. But I think that there is a change of mind and heart on the part of the Supreme Court, because in deportation proceedings, which is neither criminal, which is not criminal in nature, the deportee or respondent is entitled to bail. And the ruling is that the Constitution gives the right to bail to any individual accused of a crime. And there is a distinction between absolutely bailable criminal offense and an offense which is capital in nature and might be the subject of provisional liberty by bail only if it can be shown that the evidence of guilt is not strong. In deportation proceedings, the ruling is that the right to bail is available to anybody who is deprived of liberty or is detained, even in administrative proceedings. So there is a right to bail in deportation. Now, you can defend an extradition treaty, rather an extradition case. I defended a Filipino who is under extradition here in the Philippines. He was accused of murder, killing his wife. Initially, when he was indicted by the grand jury, there was no evidence against him, so he was released, and he was able to get the insurance, collect on the insurance policies of his wife. He came home. After so many years, a former worker testified that while in prison, a Mexican, another Mexican worker told him that my client here in the Philippines, who is subjected to extradition, killed the wife and made a statement. But based on the hearsay testimony, what they call niche, in prison, my client was indicted for parricide. And so, he was wanted in the United States after so many years. And an extradition was filed here. I succeeded in dismissing the case because in the Philippines, a hearsay testimony is not admissible and is not sufficient to establish probable cause. But in the United States, even a hearsay testimony of somebody who was given the information, even in prison, would stand as evidence. And so, the case was tried in Manila, and I succeeded in dismissing the case on the ground that the double the requirement that if it is punishable there, it should be punishable here, and then the question of evidence involved. So I got a dismissal of the case. The client I have not seen since he was acquitted until now. He is from Bicol and he never came back. Now, custodial interrogation, where a person has been arrested on probable cause or by virtue of a warrant of arrest. He may be subjected to custodial interrogation, but the requirements are very, very strict. Number one, there should be a warning of the Miranda ruling that you have the right to remain silent. Anything that you have anything that you will say in this investigation may be used against you in a court of law. You have the right to a competent and independent counsel. If you will waive your right to counsel, it must be done in writing in the presence of your counsel. If you do not have, if you cannot afford to retain a counsel of your choice, we will provide you with counsel de officio, and a PAW lawyer is qualified as a counsel de officio. Now, a lawyer who is a police member of the police in the same station is not an independent and competent counsel. And the investigation must be put in writing. So those are the stringent requirements. But when the Supreme Court want to convict, this can be sidelined by the Supreme Court. I defended a multiple special complex crime of homicide with rape. The only evidence against the client is the earring allegedly found in the earlobe of the accused. Impossible. If that was the earring of the victim, it's impossible that my client would wear it. But anyway, so I objected to the presentation of the earring. It was my objection was denied. It is a fruit of the poisonous tree because that is the only evidence. There is no positive identification. I was even asking for what do you call this? To examine the specimen and to check whether whether there were semens that belong to my client. But then it was not approved by the court, and the court convicted my client. To my mind, it is a gross violation of constitutional rights, and that there is no sufficient evidence because when the witness first testified, he did not identify my client. But then after a month, he testified and he said that he saw the grass collected to be fed to the cow that belonged to my client. But that's all. That's not sufficient evidence that he raped and killed the victim. The case went to the Supreme Court at that time on direct appeal. And so I raised the issue of violation of RA 7439 on custodial interrogation. The only evidence was the earring, and I said that is planted because number one, he would not be crazy to be wearing that during the custodial interrogation. And number two, there was no Miranda warning. And number three, there was he was arrested without a warrant. He was and the earring was seized on the theory that on the plain view doctrine. But I said that is not applicable because the police officer did not find it accidentally. It was found on purpose. And the requirements of plain view doctrine would not apply. And most important of all, since there was no Miranda warning and the requirement under the law that the custodial interrogation must be reduced in writing and a report must be made. That was not done. The Supreme Court noted all these objections, but just the same, affirm the conviction. Now, to me, that is a gross injustice, because I believe deep in my heart that they were not capable of making such heinous crime. And when they were scheduled, the three of them were scheduled to die in the electric chair. Even the plug came to our aid, and an international Amnesty International interceded, because similar crimes continued to take place in the same place, in Lemery, Taal, even after they were arrested, and they continued for so many years. And so when they were scheduled for to die in the electric chair, the Amnesty International and the plug interceded. The night before, I emailed an appeal to President Joseph Estrada, and he suspended the electrocution, because we even have the recommendation of the priest in Muntinlupa, saying that they were not guilty. Now, I do not know if they are still there, and I think that I better do something to work for their pardon. No, just one important point. The right of the local government to impose realty taxes. There is a distinction between a government instrumentality. The local government cannot tax properties of the government or its instrumentality. Now, this was explained by the Supreme Court in the case of Manila International Airport versus Court of Appeals. What was involved was the real estate taxes imposed by Mayor Marquez on Manila International Airport. The Supreme Court held that the local government unit has no taxing power or cannot impose real estate tax on the property of the government or its instrumentality, like Manila International Airport. Now, exception. Even if it is property of the government, the moment that it is leased out and it is used in business, it becomes taxable. A distinction is made by the Supreme Court in this Paranaque case. I am familiar with this case because I filed the motion for reconsideration for the former mayor of Paranaque, I think Wally Ferrer, or I do not recall now, but I was retained to help in this case. The exception is this: the local government unit might tax GOCC, government-controlled or operated corporation. And as I have said, I think in the first session, a public corporation, a government corporation might be organized only as a stock or non-stock corporation. uh, under two mandatory conditions. Number one, it must be for the public good and based on public interest. And number two, it must be economically viable. And the reason for this is so as not to waste public funds. Now, there is a provision in the Constitution that now government owned or controlled corporation, these are corporations that are doing proprietary function, not strictly governmental function. Now, the reason why the national government or property of the national government, like the MIA, which is registered in the Republic of the Philippines, and the Manila International Airport, which is a government instrumentality doing governmental function, this is not subject to tax. However, a government-owned or controlled corporation which is proprietary and engaged in business, example, a government bank, there are two requirements, public good or public welfare and economic viability, and must be organized as a corporation under the General Corporation Law, and that is a specific constitutional provision. The distinction between a public corporation and a government-owned or controlled corporation, which is engaged in proprietary and not strictly governmental function, which must be organized under the General Corporation Law as either a stock or non-stock, non-profit corporation. You want to see this in my green study guide, pages 45 and 46. So it's 12:10 and I hope that we can continue. Maybe we have to change the time, because I have accepted starting October 9 to teach commercial criminal law review with Dean Kicho at Universidad de Manila, and I do not know if that is a pre-bar review or a regular fourth year bar review. So until next time, we'll see you again. I will see you again.
Saturday.
You're welcome. My pleasure.